Good afternoon, everyone. I will now call the hearing to order. As directed by Manitoba Health, we're requesting people avoid close contact within 2 meters with anyone showing symptoms of a respiratory illness, such as coughing or sneezing. If you are experiencing flu-like symptoms, we are requesting that you excuse yourself from this meeting room. I believe we have no other participants from Zoom. Is that right, Belen? Okay, thank you. I would like to begin by acknowledging that we are in Treaty 1 territory and the traditional homeland of the Métis Nation. This afternoon, I will be chairing the hearing. My name is Robert Hutchings. Joining me on the panel is Ms. Rempel and Mr. McIntyre. Our assistant today is Ms. Rojo, and representing the Assessment and Taxation Department is Mr. Pohl. We will be hearing applications for revision of the assessment roll in accordance with the Municipal Assessment Act. The matters for which revision is requested have been described in each application, and we will limit discussion to those matters. The statements that are made at this hearing are sworn testimony, and anyone speaking to the matters must be sworn in. Be advised that comparisons of assessments of properties are not considered evidence of market value by this Board of Revision. The Board of Revision is appointed annually by Council and is independent of it and the City Administration. It makes its decisions on the basis of the evidence provided at this hearing and issues a written order that will be mailed to all parties as soon as possible. Please note that the Board's decisions with respect to an application may be appealed to the Manitoba Municipal Board if the matter pertains to assessed value or classification, or to Court of Queen's Bench if the matter pertains to the application of exemptions from taxation. Should you wish to appeal, information on how to do so will be included with this Board's order. With respect to the hearing process, I will confirm these matters to be addressed with each applicant following their swearing in. We will then have the assessor's testimony, followed by cross-examination by the appellant first, and then the panel members, and then the appellant's testimony, followed by cross-examination by the assessor first, and then the panel members again. Each side will have an opportunity to summarize if they wish. Once all the evidence about an application has been brought forward, the applicant may leave. The process will repeat for each item on the docket today. The session will close after all the applications have been heard, and the Board will deliberate in private and make its decisions based on evidence presented here today. You will receive the order by registered mail as soon as possible. As information, all public hearings are live streamed, recorded, and will be part of the public record. And please, can everybody, before we begin, put their cell phones on complete silence. All right. Could the Secretary please swear in the assessor? And the first property in the docket we'll be dealing with is 1717 Waverly Street, Unit 500.
You affirm the evidence you about to present is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please state your full name.
Rocky Newfield.
You affirm the evidence you about to present is the truth, the whole truth, and nothing but the truth?
I do.
Please state your full name. You affirm the evidence you about to present is the truth, the whole truth, and nothing but the truth? Thank you.
Thank you, Ms. Rojo. Okay, first property in the docket today is 1717 Waverly Street, Unit number 500. Good afternoon to both parties. Looking at the briefs filed, I note, Mr. Pohl, that there's a request for a burden of proof for non-compliance on this property. So perhaps we'll deal with, maybe read the details of the property and then we'll deal with that issue, please.
The roll year is 2020. The address is Unit 500, 1717 Waverly. The business assessment ID number is 3947-2. The business name is Walt Morris Pre-Owned Supercenter, and the business owner is 6035460 Manitoba Limited.
You know, Mr. Pohl, I forgot to remind you, the panel members only have electronic copies of the briefs submitted, all the information submitted. So we're going to be looking at the briefs online. So maybe when you change documents and that kind of thing, if you bear with the panel members to get to that document before you continue with it.
Okay.
Thank you.
Oh, this is just the first brief So we're asking for section 53.3B, the Municipal Assessment Act, to be seeking non-cooperation for. And if there's a reduction, that it follows section 54.3.2 and to maintain the assessment. So if we go through to the next page, this is an owner-occupied property. It's a car dealership. If you look at the page over that, page 4 or 5, it is the comparison sheet that we have for the quantum argument. But on the last page is the order for the real property. It was proven that it's owner-occupied. We asked for the non-compliance penalty to take effect. It was granted by the panel, so that's already been established at the points of failure and awarded by and granted by this panel. So in that vein, the property owner is also the tenant. If you look on the next document, I'll go through that now. Baltimore's pre-owned supercenter, which is Manitoba Limited number 5998940. Turn over to the next page. That Manitoba Limited company is Baltimore's, so they are owner-occupied and established. And we're simply asking for the non-compliance penalty to be awarded for the business assessment as well. We'll get into further detail on that, I'm sure.
Okay, Mr. Pohl, I'm noting a municipal board decision included in your brief. Is that correct?
Yeah. Sorry, I guess we can get into that now.
Yes, please.
Basically, this is the Manitoba Hydro building. It was point number 1. I've discussed this prior in my MC's hearing. So point number 1 is do the deferral penalty provisions of the Act apply to the City of Winnipeg business assessments. After a vigorous argument presented by both sides on that day, it was both myself, Kaylin Bombach, and Mr. Jamie Mercury and Rob Slaughter, Altus. Point number 1, do the deferral penalty provisions of the Act apply to the City of Winnipeg business assessments. They answered that in full. That will be on page 23 of the order. Basically, if we go through it all, the last summary paragraph says, after review of the application of the legislation and consideration of the evidence and arguments presented by both parties, the board finds that the deferral penalties and provisions of the Act apply to business assessment in the City of Winnipeg. So, in totality of the arguments that were presented, just to give a background, a bit of the history, the answer to the first part, do business assessments get non-compliance in the City of Winnipeg? Yes. The second part was, did we prove the individual failure of the subject property and appeal on that day? On that day, we did not meet that onus, so they denied the non-compliance penalty. The major points were that we didn't have the right title, and that the information that we were seeking at that time in the board's eyes wasn't relevant to what we would have put on for the business assessment for the occupancy costs. So I disagree with that point, but that's what the panel found. So based on this order, I feel that non-compliance should be applied. We've proven that the ownership and the property and the ownership of the business is the same for the subject property under appeal here today, and I feel it should be applied to the deferral.
Okay, Mr. Pohl, I'm going to ask if you could speak up a little louder when we continue. Thank you. Anything else to say on the issue of request for non-compliance?
No, in my eyes, it's pretty clear. Like I said, it's a yes or no question. As long as you prove that it's owner occupant, it's the same as the the ownership group is the same as the real estate, real property, then it's should be awarded by this panel. And the fact that the failure has already been proven with realty speaks for itself.
Okay. Thank you. Any questions from Mr. Mercury or Mr. Neufeld, please, of the assessor's evidence presented so far?
Yes, I have some questions, Mr. Chairman.
Thank you.
Mr. Paul, with respect to your brief that you filed, the copy that I have is your initial brief is a 5-page document, which the last page of which appears to be the board revision order on the realty. Is that correct?
Correct.
In your material, or I guess perhaps most important in the board's material, is there a copy of the realty brief that was submitted by the city assessment department?
No, I have a copy here today,
But
like I said, it should have been included. Not that doesn't prove the failure. It's already been awarded. What it proves is the secondary copy of the information you should have, which was submitted on Monday.
So just so we're all clear that you've included the order, but you have not included the actual mailer, i.e. the request for information that would have been sent to the owner, correct?
No, I have not. It appears that document didn't make its way through.
So you would agree with me, though, that in those, that is a standard form mailer that would have been sent to all businesses in the city of Winnipeg, correct?
All real estate, yes.
Of all real estate. And that mailer will have referenced the realty roll number, the 2020 realty assessment roll number, which in that particular case was, as noted on the border revision order, 03091449300, correct?
Correct.
There would have been no reference to a request for information being made with respect to the business assessment role specifically on that mailer, correct?
No, there wouldn't be a business assessment.
Okay. And so reference the hydro decision, which was a bit of a test case to resolve some of these issues, correct?
Right.
You were involved in that case. And you do recall that there were a number of arguments raised by the owner occupier, in that case Manitoba Hydro, as to why a deferral penalty should not be granted in the context of a business assessment appeal contrasted to a realty assessment appeal, correct?
Yes, there were a number of variables to the argument.
Right. So the first argument was that penalties in the context of business assessments, it's not contemplated by the legislation, correct? That was the first argument.
It was inexplicit.
Right, and the board found that no, you can request deferral orders in the context of business assessment appeals. I think you've established that, correct? But they then went on to ask themselves, you still must nonetheless prove a failure within the meaning of the act before you get the deferral order, correct?
Absolutely.
Okay, and so the municipal board, you will agree with me, at the end of the day, dismissed the city's request for a deferral order on more than one grounds, correct?
Yeah.
Right, so the first ground was that it wasn't sent to the correct address for service, correct? And the second ground, a second ground, was the fact that there was no further reduction by the municipal board, and therefore there was no jurisdiction to grant it on that basis, correct?
Yeah, that's
okay. But for our purposes, one of the arguments that you will recall was that was raised by Manitoba Hydro and addressed specifically in the decision was that with respect to the mailer that was issued, there was no specific reference to the business assessment role, and therefore there was not a specific request for information as it relates to the business assessment. Do you recall that?
Yes, I do.
Okay.
That was one of the points that were raised.
One of the points that was raised, and you also agree that the board dealt with that argument in its order, correct?
Correct.
And so if we look at the actual order, let me just locate it here. Does the board have the hydro decision at its in its computer?
Yes,
accessible? Okay.
Yes, we do.
Okay, if you look at page 25 of the decision, and specifically the fourth paragraph down. Does everybody have that?
I am just getting into it now. Sorry, Mr. Mercury, page 25.
Page 25, yes.
Yes, okay. I do have it in front of me now. Thank you.
Okay, so this would be the fourth paragraph down, beginning with the board adds.
Yes.
Okay, so Mr. Pohl, you'll agree there that it states that the board adds that even if it was established that the INE request did find its way to the owner, the board finds that the first INE request lacked any reference to the applicable business assessment roll number. It was therefore not clear on its face to properly convey to the owner the assessor was specifically requesting information pertaining to the 2016 business assessment. You recall that?
Yes, I do.
Okay, so you will agree that this was an additional ground upon which the city's argument for deferral penalty was not allowed.
That's the wordage that's being used.
Okay. And that decision has not been appealed further by the city, has it? Those are my questions for Mr. Pohl. Thank you.
Thank you, Mr. Mercury. Ms. Rempel, any questions of the assessor regarding the burden of proof?
No questions, thank you.
Thank you. Mr. McIntyre?
I have no questions.
Okay. And I have no questions either. Mr. Mercury, when you're ready regarding the request for burden of proof?
Yes. There are, I was present with Mr. Neufeld at the realty assessment hearing when this was argued. And while the owner certainly disputes on the facts that that non-compliance was made out, and Mr. Neufeld can speak to that if necessary, there was an order that was made as to non-compliance. What's important for the board to understand in this case and in all subsequent cases that you will hear with respect to 2020 business assessment cases where a deferral penalty request is being made is that you must have regard to the Manitoba Hydro decision, which was brought forward by the parties by agreement by the City of Winnipeg and the owner in that particular case, with Altus involved, who represents a number of other property owners. It was to try to clarify the law with respect to in what circumstances the Board of Revision or the municipal board can grant deferral orders in the context of a business assessment appeal. So we've established, thankfully, because there were board decisions going in both directions, you may recall in the last cycle, in some cases granting a deferral order, some cases they were not. So this case allowed the municipal board to clarify that issue, thankfully, for both parties to resolve, yes, it can apply, but what are some of the points that must be established by the city before a deferral order will be imposed in the context of a business assessment? And what they've said very clearly is, for the context of this case, is that in light of the wording that is used on the mailer, which only refers to the realty assessment role, that is not specific enough. It is not a clear enough request to the owner so that they fully understand that they are being asked to present information not only with respect to the realty assessment, but with respect to the business assessment process as well. The mailer that would have been sent in this case, although it's not even in evidence before you, would have been, I think we're all in agreement, there's no disagreement, that form, the mailer, would have been identical to the form that was used in the Hydro case. And so I pointed you to page 25 of that decision, which indicates that unless there is specific reference to the business assessment role, your request for non-compliance will be denied. There were other reasons for denying the request in that particular case, but this is the decision of the municipal board, and my submission is correct. It's one that should be followed by certainly this board, because the whole point of that process was to provide guidance and direction to future cases involving business assessments. This is a matter that can be remedied by the City of Winnipeg Assessment Department in future years, simply by amending the form of notice that they provide and making it clear and unambiguous as to why they are requesting information and for what purpose. But in light of the wording that has been used, which has been interpreted by the municipal board, clearly a deferral order is not appropriate in this case. I would add to that, just very quickly, Mr. Chairman, is another recent decision from the municipal board, a very recent decision. It dealt with a deferral penalty. This was in the realty context, but this case is called, it's another case involving Boeing Canada Operations, 99 Murray Park Road. And what happened in that particular case was the city sent a request for information to 99 Murray Park Road, which was the address of the property at issue, and it had been doing that for a number of years. There was an intercompany transfer of title between related Boeing entities, and on the new title, the address for service was, it turned out to be an address in Alberta. So the city sent the follow-up mailer to the Alberta address for service on title, and somebody signed for the mail. And nobody could establish who that person actually was. I believe the person's name was L. Smith. Do you have the Boeing decision? I think it was emailed to you, Mr. Chairman, members.
Mr. Mercury, with all due respect, is this relevant to this case at all about not the owner not receiving the mailer or anything?
It is, in the sense that it's a secondary ground for denying the penalty, and that is the onus on the assessor to prove that the person who signed for the mail actually had authority to sign on behalf of the owner. So it is what the municipal board said. This is a very recent decision. Right. Is it enough for someone to simply scribble their name on a form and for the city to show up with that acknowledgement of receipt card and say, we've proven service? And what the municipal board has stated in this case, which is the most recent decision on non-compliance requests, and I'm looking, if you have it, it's at page, although it's not necessary to answer your question earlier, this is not necessary to dispose of this particular appeal, but this is relevant to not only this appeal, but many others that will come before you. Page 7 of that decision clearly states that this is the middle paragraph in the beginning with the board finds, the comments. And halfway down, it says, unless the agent is held out by the owner to have authority, the assessor must prove that the INA request was brought to the attention of the owner. In the case of this appeal, the registered letter was received and signed for by L. Smith. However, the assessor has not established the owner held out L. Smith as its agent or was authorized to accept delivery on the owner's behalf. But furthermore, there is no evidence that L. Smith brought the second INA request to the owner's attention. And so, and then following page, they conclude the assessor is not satisfied the owner is proving that a proper INA request was made and received by the owner. And the request was denied. So that is a secondary issue. And in the present case, we don't even have the INA request. There's no evidence to who actually signed for it, but this decision obviously postdates the realty order that was made by this panel. So I bring those to your attention. I'm certainly subject to any questions from Mr. Pohl or the.
Okay.
Thank you.
Thank you very much. Mr. Pohl, any questions?
Yeah, I got a few. I just want to generally frame the argument down to the main points. Are you saying that, just to be clear, the real property and the business both have common ownership? You're not denying it?
No, Mr. Neufeld can speak to that particular issue on the facts. They don't have common ownership from what I understand.
So Walter Morris isn't involved in the real estate and Walter Morris isn't involved in the businesses?
I think that's a question better addressed to Mr. Neufeld. I didn't address that particular issue. It's not necessary for the purposes of my submission in terms of the ownership group here.
How would not ensuring that there's common ownership between the real estate portion and the business assessment not be part of your review? That's the link that allows.
Well, in the Manitoba Hydro case, we had one owner, one occupier, Manitoba Hydro. So
I don't think anyone in the room would argue that the Manitoba Hydro building wasn't owned by Manitoba Hydro.
and occupied,
So, right. So there is a link there that has to be established.
right?
Did you check to see that that is the fact today?
Just so I'm clear, the owner that is identified on the brief is 6035460 Manitoba Limited.
Yes, and as you go through the secondary brief that I went through, it proves it's Baltimore's.
The share ownership, is that what you're referring to?
So,
Okay, so it's not the same company to answer
in
your
your
question.
legal opinion, there is not common ownership.
Whether the shares are owned by common entities is not the question of whether the same entity. They're separate corporations.
So it's, in your eyes, not owner occupied then? Do we have a tenant situation here where there's arm's length tenant from the ownership?
Well, is there a common director or a common shareholder? I don't think there's a dispute. The corporate documents will speak for themselves, but that is not the thrust of the submission in this particular.
No, but it's one of the check marks that has to go through, that has to go.
All right, I'll leave that for the city.
What I gathered from your submission was we had an entire argument for point number one. Does business assessments and should they receive the program?
Yeah.
That was answered yes.
Correct.
Right.
Yes.
So when we went through the whole argument, you used a number of times that it wasn't explicit language used. It wasn't clear enough. We used section 9.1, which general assessment. It wasn't clear enough. Yet the board found that yes, it was.
The board has determined that you can request deferral penalties in business assessments. That's been established, yes.
So on each and every single mailer, there is 9.1 on every single mailer going out, which encompasses both roles.
Section
Ask you
9.1
to
was,
speak.
Sorry, I don't know. Sorry. Maybe it's the acoustics in the room. I don't want to know.
we're going through arguments that have been,
No, I'm just
addressed.
narrowing it down to the panel and for ourselves.
Yeah.
If this moves forward. So it's the fact that 9.1 isn't explicit, isn't enough for you on the mailer. You need to see the business rule.
Correct.
Can I show you something before answering your questions? Okay. It's taxable party. Here's all the searches. Wait, there's some more.
Yeah.
There's a different.
So your main point here today, it is not explicit that there is a business roll number on the mailer. But
That's what the municipal board has decided this question.
So out of all of the issues, it's just the one paragraph that you have an issue with, the minor point.
Well, so there's 2 points. Number one, we don't even have the mailer in evidence in this appeal. So on that basis alone, the penalty request must fail. I think we're just making assumptions in terms of what this actually says. It's not in evidence. But with respect to what is required to be on that mailer, the municipal board has made itself very clear. I could stand here and argue again that the Municipal Assessment Act and does not contemplate penalties in the context of business assessment appeals, but I would basically be arguing that this panel should be reversing the municipal board. I'm not going to do that. What I'm here saying is that all parties present in this room and the panel should respect the decision of the municipal board, which has made it very clear that one of the grounds for refusing a deferral request in the context of a business assessment penalty case is there must be specific reference to the business assessment rule. And if there is not, if that wasn't good enough in Manitoba Hydro's case, it certainly shouldn't be good enough in this particular case. So I'm not going to re-argue everything that was advanced, nor do I think it's appropriate, frankly, for the city to be doing that in the context of this proceeding.
Okay, so you're relying solely based on,
Well-
my understanding is solely based on the principal point, the B roll number is not.
Well, that principally, the secondary point is taken from the Boeing decision, which was released a few weeks ago, with respect to leaving that issue aside. The municipal board has found that it is not sufficient. This is a decision that well postdates the deferral order in the realty case here, that you must establish that there is authority in whoever signed for that mail. This isn't even in evidence, so I don't know who signed for it. We haven't even got into that issue. That's a secondary ground upon which this should be dismissed.
All right, that's all the questions I have.
Thank you, Mr. Pohl. Mr. McIntyre, any questions of the appellant?
I have no questions.
Thank you. Ms. Rempel?
My question has been answered. Thank you.
Okay, thank you. Okay, so I'm just trying to get this clear. Mr. Mercury, I guess I'll speak to you. So in reference to the municipal board order from Hydro, are the circumstances exactly the same with the subject property today as that Manitoba Hydro decision in regards to, I think reading over that municipal board order, it seemed like there was a mix-up with the I&E being delivered. Is that right? And that was an argument?
So just to answer your question, there obviously were different circumstances, but with respect to the point that we're talking about today, that is what is on the mailer and what is not on the mailer.
Okay.
Remember, there were several grounds in Hydro for arguing that the deferral order shouldn't apply, some of which aren't relevant to this particular
Okay.
factual, but the one point that is directly on point and is factually identical, Mr. Chairman, was the form of the mailer that was issued. And although we don't have them, I think Mr. Pohl and I are prepared to agree that the form of the mailer in this case would have been identical to the form of mailer that was considered by the municipal board. And what they said is, in light of the manner in which that form was prepared and notice given or not given to the owner, that's not sufficient. And so that, in my view, that case, that decision has not been appealed by the city of Winnipeg. So it was brought before the municipal board as a test case to try to resolve these issues. So I would hate to think we'd be back before the municipal board arguing before a different panel on this again. That is the state of the law. As I said, it can be rectified fairly easily by the city in future cases simply by amending the form of notice that they use.
Okay. So just to understand, you're saying your interpretation of the municipal board order is that the income and expense statement that the city sends out is not worded correctly and is invalid for allowing any deferral of the business assessment appeals?
Yes, so to reiterate, page 25, middle paragraph says that even if you establish that it's been served to the right address, the right person got it, what they said is that notice lacked, quote, lacked any reference to the applicable business assessment roll number. It was therefore not clear on its face to properly convey to the owner that the assessor was specifically requesting information pertaining to the 2016 business assessment. And remember, section 16.1 talks about information required for the assessment. So unless the notice says I'm looking for information for not only the realty assessment, but the business assessment, that mailer is not sufficient. That's what the municipal board has decided.
Okay. But then what's confusing me is Mr. Pohl pointed out that the municipal board also said that a deferral of business assessment is allowed.
So as a matter of law, there's a threshold question as to whether, because business assessments are issued under the City of Winnipeg Charter and they incorporate by reference the penalty, certain provisions of the Municipal Assessment Act, the legislation wasn't worded all that clearly as to whether or not we can even engage in this debate. But what the municipal board says is that, yes, you can ask for deferral orders, hypothetically, you can, but you still have to prove service notice, a proper request was made, and all of the other criteria. So the city established that yes, as a matter of law, you can ask for it. And to put it another way, Mr. Chairman, if this notice had referenced the business assessment roll number on it, and they established that it came to the correct party and entity, a deferral order would be appropriate. But in light of the mailer that they have used and the lack of evidence regarding who they served, when you look at the Boeing decision, the municipal board has clearly stated on those facts. You have to look at the facts of each particular case, of course. Deferral order is not appropriate.
Okay.
Does that help answer your question? Hopefully.
Yes. Thank you, Mr. Mercury. I think Mr. Pohl's got a comment to make.
I just want to make sure it's clear for myself moving forward. We have an entire, as your own wordage says in your, as we argued, and I can rehash what we did on that day. There is no explicit wordage that gives you, that allows the act to apply, the charter to apply to the act, that gives you access to only for business assessment. The municipal board said no to that and awarded and said, yes, you can. So a whole interpretation of both charter, both acts, come down.
Yeah.
But you're relying on two sentences in this order, which are then explicit to undo that argument.
Well, I'm not sure. I'm not undoing any argument. The wording of the municipal board in page 25 is very clear, and the facts of this case are identical to what occurred in Manitoba Hydro. The mailer was identical.
And which gets down to the major point, which in my eyes is when we declare on that form, and I'm sure you're not going to disagree that we declare that we're seeking this information for comparative roll into 9-1, which encompasses everything.
Well, that argument was raised and dismissed by the municipal board, Mr. Pohl, because that was not sufficient for making a proper request under Section 16. That argument was raised and it was dismissed.
I think we got to the crutch of where our positions are.
Okay.
If there's any disagreement as to what the municipal board decided, I think the question is whether this board wants to follow that ruling, and I feel that it's appropriate that they do so.
Okay, I think any requirement for summary? I think you both summed up your points. Mr. Neufeld?
I have I don't know that it's necessary, but I put into written form effectively what I've submitted. The board's welcome to have it. It's just repetitive of what I've stated orally. Was it submitted with the
Yes.
It was. Okay, I don't know, Mr. Foley, you have that? Okay, it's just.
Excuse me, Belen, do we have that in our documents on the drive?
Yes, so last one for item 1 called supporting brief, applicant supporting brief.
Okay, so item 1, okay, bear with us while we locate this docket, Mr. Mercury.
It's effectively a verbatim submission that I had made in the context of the Manitoba Hydro case that was accepted, and I felt it might be helpful for the board to have it.
I am still trying to get it open here. Bear with me, please.
Again, this won't be any new information for you, Mr. Chairman. It'll be a summary of what I've just articulated.
Okay, I've got it here. Do the panel members have it available?
Yes, we do.
Okay. All right. Okay. I've got that up. All right. Anything more that either party would like to add before we recess and discuss in camera how we're gonna deal with this request for non-compliance? Mr. Mercury, you're good?
I'm good. Thank you, Mr. Chairman.
Thank you. Mr. Pohl?
I'm good. I think I narrowed it down for the board.
Okay, thank you. Okay, could all parties please leave the room? And Ellen, could we go in camera, please? Thank you, Belen. I will now call the hearing back to order. The panel has carefully considered the arguments presented by both parties, and it is the panel's decision that the request for non-compliance be denied in this case. So we will proceed with Mr. Poole with the VA appeal for 1717 Waverly Street, Unit 500.
Total land or rental value is for $240,900. The total area of the premise is 14,340 square feet. And per square foot, that works out to be $16.08 for the square foot rate. The base ARV is $205,779, which works out to be $14.35 a square foot, with the occupancy costs totaling $35,133, gives you $240,900. It is an owner-occupied property, so there are no rents in the property. If you look at our comparable sheet on page number 4, and I know the panel's heard this argument before, so I'm just going to briefly summarize it. We don't have regular shoot leases to examine and bring in and use. They're all occupied. The entire populace, the franchisee dealerships are occupied. So what we go out and look for is the most similar structure that's leased in the marketplace in a retail location to apply to the subject property. So we go out and we look for retail nodes, we look for slab on grade construction, steel frame walls, steel roof, big box store type properties. We take what the property owners here, if they weren't going to be owner occupied and were to go out into the marketplace and look for a similar building, similar utility, what would they have to pay for rent? Well, they would have to pay what the market pays to starting point, which would be the comparisons we have here today. So we have for a little over 500,000 square feet of inventory for 27 comparables. We have an average rate of $18.86 a square foot, a weighted average of $18.05 a square foot, and a median of $18.29 a square foot. So based on those, we feel that a rental rate of $14.35 is reasonable. And I'm open to questions.
Thank you, Mr. Poole. Mr. Neufeld, any questions of the assessor's evidence?
Yes. When was the last inspection?
I haven't done an inspection on the property. I couldn't tell you.
I didn't mean specifically you, but when was the last time the assessor was out? Do you have that in your file anywhere? So you don't know if they've been out since the change in the dealership, the manufacturer they represent?
That's not a point that I looked at.
But you haven't been out there since then?
No, I haven't.
Okay. And you mentioned the comparables. Are these the same comparables on your page 4 as were utilized in the realty presentation?
Yes, they should have been, yes. And indeed they are.
And did you have a chance to review the realty decision?
Yes, I have. It's on the following page. The decision was a reduction from $2,740,000 down to $2,372,000. And the details from this panel were based on an adjusted net operating income and a capitalization rate of 7.25%. I believe there's also minutes of board filed on this property by Colliers.
Now, there was a change to the income as well as the cap rate then, correct?
That's the order indicates, yes.
Sorry, I'm just catching up here. The income that was applied for realty, was that the same income that you're asking for today? 1435 a square foot. So this is the same number that was in place for realty that the board ordered some sort of change, and but you're back at the same number then today.
Correct.
Okay, those are my questions.
Thank you, Mr. Neufeld. Ms. Rempel, any questions of the assessor?
No questions, thank you.
Thank you. Mr. McIntyre?
I have no questions.
Okay, thank you. And I have no questions either. Mr. Neufeld, when you are ready, please.
Well, there are two issues for this property. One is the amount of rentable area, which has changed, and the second is the value that should be put on this. So we'll start with the latter. On page 3 is the excerpt of the Board of Revision decision. And you'll note that the evidence presented by the assessor is the same evidence that this board has already heard and have already rendered a decision on. The adjusted net operating income on our workup on it would indicate that the rent was changed from $14.35 to $12.60. And I think this is fairly straightforward because we were using this, that we're assuming the same parameters have been applied for both workups. Now, the board didn't give us any sort of other information than this, and I know that the chairman is here, and I know you can't testify about what your decision was. Perhaps in the future, to avoid these conflicts, more detail if that's convenient. But I think we're making a fairly safe assumption that it was changed to $12.60 a foot, and there's no new evidence before you. And I don't know why one would have the expectation that if you present the same evidence twice in a row, that it would change anybody's mind. We have appealed it, and we've appealed it for, obviously the reasons of the penalty are one issue, and the value is another issue. But the $12.60 was the rent, and I believe you should apply your same decision as in the past, and the parties can then decide where they'd like to take this further. I don't think the board should be changing its mind. Interesting, I had this debate this morning. Someone asked me, the assessor asked me, well, it's trial de novo. They can do whatever you want and change it. And I think trial de novo is a right, not a requirement. And nobody brought you anything new, not me, not the assessor. So regardless of that, so we've applied $12.60. Now the other problem is the square footage. From the time this building was built, there have been problems with the square footage. And originally, I think it started its life off, the assessment department had it at 17,000 feet, then it changed to 16,000, and finally it's at 14,340. And that's for a couple of things. There's some second floor space, and there's a curve in the building, and not all the space it runs through on the second floor. So that has been remedied. Now, the property was designed and built for a specific use, Suzuki dealership. Suzuki, at the time this building was built, manufactured and sold cars, snowmobiles, and motorcycles. They were all sold in one property. So the template for Suzuki was sell the cars on the main floor, snowmobiles and motorcycles were on the upper floor. And there is an elevator, not big enough for a car, but it fits a snowmobile or a motorcycle. The service bays were very, very small. There are, I believe, 5 or 6 service bays. So it was designed for the Suzuki product. Now, Suzuki made a corporate decision to pull out of marketing cars about, I think it was 5 or 6 years ago. And that's why they no longer exist. And there's obviously not enough momentum to sell motorcycles and snowmobiles under the Suzuki label. They have gone to locations to sell them where they're selling other brands. There's not enough business for just that brand. So for 2 or 3 years, the same owner operated a used car business. And at that point in time, pretty much abandoned the second floor. Then 2 years ago, they managed to get the new Alfa Romeo franchise. And the spec on Alfa Romeo is no second floor work. Because first of all, you can't even bring a car. So the upper floor has been vacant since that time, which is 2 years ago. I've been in the site, I'm going to say 6, 7, 8 times. And there's absolutely nothing on the second floor. Not a lunchroom to use. Well, actually, I shouldn't say that. There's a small controller's office at the back for a different business. There used to be a call center there. There's no call center. It's deserted. There's no computer setups. their lights aren't on, it's just not in use. So this is a question where we have an obsolete building that was designed for specific use, which is now over. So in my opinion, you're not carrying on business there. There's obviously no chance for profit. Some of the thoughts that have been put to the site, and this is kind of interesting, we approached my little informal group about perhaps using the space for club meetings, non-profit car club meetings. So that is a thought that they have put to the site, and that's not an original thought, because the Harley dealership on Oak Point had the same concept when it was built. But the point is, it's not in use and it's not generating any business. So we were only saying that 1260 should be applied to 9,368 square feet, which is the main floor. And the last issue, which we missed here, is that there is not air conditioning in the entire building. The service shop, the back portion of the building does not have it. I did not give you those numbers, so I don't know what they are offhand. So my fault, we're not going to make a change on that, but that number is incorrect. That's my presentation.
Thank you, Mr. Neufeld. Mr. Pohl, any questions of the appellant's evidence?
Just getting to the square foot area, there's a difference of 14,340 square feet versus 9,368 square feet. You're saying the residual amount is not being used?
That's correct.
Is this a 2 CRU building? Or a single CRU building?
It's actually set up for, it's got a separately demised entranceway and restrooms on the upper level. On the west side of the property, there's a common foyer, which is lockable to allow for 2 separate rental units right now.
Okay. Has there been any active advertising of this for Colliers, or has there been any active leasing opportunities here?
I mentioned the approach they made to our car club and the discussions we've had. I don't know what the other efforts have been to market the site.
Would it be typical for a high-end dealership to want to have a car club on their site?
Yes, they all do it.
Fair enough. Your rental comparisons. You're using page 5, I'm assuming? Your rental auto rates.
They're presented for information. Primarily what we're saying is respect to the board of revision. There's been a decision. I'm not expecting to have a different decision on value. I haven't brought up any new data. So my primary request is we will live with the realty decision. And if we have a disagreement with it, we know we have to take the realty somewhere else. If we disagree with business, then that's a separate decision. So we're not coming here defending rental value. We're just asking for the carryover, which has been fairly customary in the 20 odd years that I've been going to this board.
Okay, let me touch base on that since you made that point. Is it typical for an agent not to get their value at the realty end of it to then come to the board of revision and ask for the same value that they originally sought for the realty?
I suppose I suppose it happens, but I think the caution one has to have is when you see that you're unhappy with the decision and you appeal it. I think that any rational person would show up with something that was better, because the board has told you that's not good enough. So you expect a different decision. Come with some better information. That's just a rule of thumb. And be clear, anybody who goes in expecting a different decision without doing that doesn't generally have an expectation to have a different shouldn't have an expectation to have a different decision.
So safe to say that the comparisons that I'm looking at were the same comparisons that you used at the realty hearing?
Not entirely.
Top chart.
I'm not entirely sure. I can check. Somebody's been messing my file up. It's not in order. I don't think I have them here. I can't find them. We've been doing a bit of housekeeping work here, and I think our filing people are handling them now, so I don't have those in front of me.
Okay. So the non-compliance element and trustee order, or for this end, trustee order, but for the non-compliance end, we didn't present the right information from Folsom. But here, you're not relying on these rental rates that you have on page 5.
Of course, I'm relying on them
So then I'll question.
in the matter of the original decision. This decision, I'm just asking for the board to reconfirm their previous valuation.
Is it safe to assume that these are the same comparisons that I've seen for quite a few cycles now, that they would be typical, that this would have been in the brief if you'd be able to do it?
I don't know what you've seen.
So then I'll simply question you on what I see on page 5. Can you please point out an arm's length tentative full service dealership?
Define full service.
Franchisee arm's length from the property owner versus the tenant.
Well, the automotive retailers that are in there, number 2, number 4, number 5, number 6, number 8,
You don't
and
have
number 9.
Can you please go by address? You don't have the number.
231 Oak Point, 3680 Portage,
Okay, listen.
2554 Portage, 3636 Portage, 1700 Waverly, and 2150 McPhillips.
Let's stop at 231 Oak Point. 231 Oak Point is Match Auto.
Oh, wait, sorry. No, that had been one. You're right. That's a used car dealer right
Car
now.
dealership in a former Harley Davidson dealership.
Yeah, it's
Property that's been vacant for several years.
it's a used car dealership with an upper level. Yeah. And again, we're struggling with your definition of full service.
How franchisee?
Well,
Name brand franchisee.
you know, by definition, to identify someone as having a franchise, you've now turned your question into a value and use question. You understand
Ford,
that?
Chevy.
No. I mean, see, you're now becoming
Or
a
used car
value and use argument.
So none of these are arm's length tenanted,
Well, 231 Oak Point is an arm's length tenant.
but it's for a used car dealership. And then if I get to the specific comparable of a lot area that is minor compared to the land building ratio for full service dealership. So the site utility wouldn't be the same as a full service dealership. It's not a comparison that you can use to compare it to a full service dealership.
Well, it is. And what you're doing in your question is you're starting to try to define it down narrower and narrower until you'll find that there's nothing that will ever match. What I'm looking at here is the real estate. A piece of real estate that has the potential to sell vehicles. And then the legal part of it is defined by an arm's length relationship. And that's the proper valuation way to look at it. And if you stray off that path, you begin looking for value in use. And that's a dangerous path.
So specifically 3636 Portage, 1700 Waverly, 2115 McPhillips, those are owner occupied or are those arm's length full service dealerships?
At the time that they were in place, they were tenanted.
Was there any common ownership and partnership between the tenant and the property owners?
I don't believe so.
Just for the board's recollection of these under appeal, it's never been a question out of other agents. Comparables number, I guess address is 1370 Dugald and 1301 Dugald.
I'm sorry, what was that last comment?
When these properties were under appeal and have been under appeal by other agents, they've been reported as owner occupied.
Is that in your evidence? Or you just making random statements?
I'm openly stating that under oath as a handle.
No, your question time here. You're making random statements here. Yeah, that's hearsay.
Getting back to your comparables, 1370 Dugald and 1301 Dugald, what are the tenancies here?
1370 is RV center. And 1301 Dugald was a sale of trailers and RVs as well, my understanding.
So these would not be in a retail location either. They would be in a more industrial end of Dugald, and they're more catering to recreational vehicles.
I don't think there's anything about selling RVs that has anything to do with industrial. That's a retail end use.
Is the location itself suitable for a full service dealership? Is there another full service dealership located?
Yes, there's a Zuzu at 2315 Dugald and a truck dealership with a Zuzu and Chevrolet. And there's another operator. There's two other sites on Dugald that are satellite operations for dealerships on Regent.
Is there franchising domestic vehicles dealerships on that?
2315 Dugald.
Your comparables below that, your auto dealer rates applied by the Board of Revision. This is a work of yourself based on your interpretation of the orders that came out from this board?
Yes, it's just for information only.
What file numbers are associated with them? What years are associated with them? Comparing an assessment to assessments to derive at what other decisions from this panel?
Well, the weight that's assigned to it is obviously done by the board, and there's no attempt to pretend that they're anything but other orders. And so in that respect, commentary is fair, and boards can assign the weight as they see fit.
So as far as economic opportunity, as far as the comparables that we see on the top chart, you feel that these are suitable comparables for the subject property, location, business that you can do on an actual property, which would generate the rent that you would pay as any tenant would.
Well, the rents that are here illustrate an attempt to look at multi-function properties and single-function properties. Now, a dealership is a multi-function property. Our particular dealership does new cars, used cars, and service, and some do auto body. So there can be as many as 4 different functions. Now, what we're trying to do is go and look at rental rates in the marketplace that perform as many functions as possible. And some of them are single function sites and some of them are multi-function sites. So looking at the wealth of information then, and then trying to look at the rates and knowing something about the business is assigning the weight to them as to what's the dominant income producing issue for car dealerships, and then weighing that and estimating a value. So that's the answer on how I looked at it.
Lastly, just speaking to the statistical analysis that your comparables show, it shows a rent range from $11.90 a square foot to $4.75 a square foot. You did not put in an average, weighted average, or a median. Why would you not be reviewing that?
Well, because it presents a false image. I think very early on in the education process for appraisal is they make the comment to us as we're training that if somebody just wanted an average, they could hire somebody with a calculator to do their appraising. That's not the function. What we're trying to do is look at the range, see where we fall in the range, and apply the best methodology possible to see where we fit. Looking at averages is done in a mass appraisal world, but the rules on that are much stricter than anyone has ever practiced or shown to this board. the concept in valuation is to perform an educated estimate looking at the range of rents in the market. Statistical analysis is more or less a violation of standards.
So in lieu of actual direct leases for comparison of other franchisee car dealerships, these are the best comparables that you could find in the marketplace to bring in.
These are the comparables in the marketplace that have rents in place.
Even though 3636 Portage is an owner-occupied River City Ford.
It is now owner occupied. At the time of the lease that we reported, which was 2009, and yes, dated, it was a rented premise. And we know this because our company did the appraisal to set up the rental rate.
It's 100% arm's length.
Oh, it's worse than arm's length. It's the strictness on the manufacturer. We've heard this conversation before that maybe Ford gives a break to certain franchisees and gives them a better rent. If you do that with one franchisee, there's 5,000 other franchisees who are going to sue you, and they all are in the United States. There is no break given. What the manufacturer does when they do own facilities is they hire an appraiser and get one, maybe two, maybe three opinions and set the rent on that basis so that it's fair to the other franchisees, to the shareholders, to everybody.
All the questions I have.
Thank you, Mr. Poole. Mr. McIntyre, any questions of the appellant?
I have no questions.
Thank you. Ms. Rempel?
I just have one question. You had indicated that there was a call center upstairs for a period of time that has now vacated the premises.
That's correct.
And I'm just wondering, when did the call center vacate the premises?
They left with Suzuki, and they went off premise subcontractor. So a lot of dealerships if you get allowed to go into the inside and find that these mezzanine levels are occupied by, we call it a call center, but there might be 2 or 3 people working and some part-time. And their job is to, I don't know if you ever had your car serviced and you got a phone call from somebody, or if you ever went to their website and all of a sudden there's a pop-up, hey, my name's Ernie, can I help you buy a new car? Originally, these were generally on-site people. So the internet ones are now done by outside service providers. And then the follow-up from service is done straight out of the service areas now, not from a call center. But I use the term very loosely. It was 2 or 3 people.
So this was a call center that Suzuki ran
Well,
on the second floor of
right.
their dealership.
There, Naz, my contact there, he had a small office. He was the controller. Beside him, there was a 3-station call center. And then in front of them was the reception area for motorcycle and snowmobiles. And then there was the showroom. And then there were 3 closer offices, as they call them, where you want to close the deal and the salesman will take them into the room. So as of right now, the only one that is still in place is the old controller's office, but it's not even for this business anymore. It's dealing with another business operated by Mr. Morris's companies. He's got this trucking company in Headingley. So I guess that office is probably 8 by 10. Maybe I missed 80 square feet that should have been on here. There's a lift on there, which is now not being used because there's nothing to lift up. And there used to be some parts storage, which isn't being used either, because it would be motorcycle parts and accessories and a motorcycle storage room. Everything is on the first floor except for that one small office.
That's all my questions. Thank you.
Thank you, Ms. Rempel. Mr. Neufeld, so there's an elevator servicing that second floor, is that right? Or is it a service elevator? Or?
Yeah, it's just freight.
Okay.
So it's not courier-free access up there. Freight elevator isn't licensed for people moving.
Okay. My second question is, so I'm just looking at your brief here, and you revised your original brief was based on the assessor's square footage at 14,340. So you reduced it by about 35% or just under 5,000 square feet. And yet you're using the same request for rent. Would it, by economy of scale, would that possibly require an adjustment upwards for 5,000 square feet less?
That's a good question, and I was going to ask you because you wrote the decision. I'm not trying to be funny, but we don't know what the numbers are. It's certainly not 1435. There was a change. I had penciled in when I was originally doing this a variation, 9,368 square feet. I found my front page. 9368, we were looking for $11, and 6823, we were looking at $8. So we had used about a roughly 25% variance in the numbers. And then, and we had erred on that 6823. So no, I can't. I don't know that answer, but it's a fair question.
Okay.
I don't know how one can decipher this when we were told there's an adjustment of some sort to net income. So do you take the 1435 and mark it down by percentage? Maybe that's an idea. I don't know.
Okay. That is my only two questions. Any requirement for summary by either party?
No, I think we covered all the bases.
Mr. Neufeld?
I think this is well thought, well debated.
No? Okay, thank you. So that concludes 1717 Waverly Street, unit number 500. Thank you, Mr. Pohl. I believe that's it for you. Is that right?
We participated in the next one.
Okay. Bellen, is Mr. Dolinsky here yet? Okay. Would the panel like to take a quick 5-minute recess before we start the second? Okay. So we'll recess for 5 minutes, please. Bellen, thank you. Okay, I will now call the hearing back to order. Next property, I guess we have to swear in the assessor, Bellen, please. Okay, Mr. Dolinsky, welcome. First property in the docket is 829, or pardon me, for Mr. Dolinsky is 829 Corden Avenue, unit number 3. And Mr. Dolinsky, let's see, we've got a request for non-compliance on this property. Would you mind reading the property in for the record and then deal with the non-compliance requests first, please?
Yes, thank you, Mr. Chairman. File number 19-5900, roll year is 2020. The address is Unit 3, 929 Corden Ave. Business assessment ID is 18916, and the owner of this premise is the Smith Agency Limited. We're asking to confirm the ARV of 35,940. The request here is that the burden of proof be placed on the applicant for non-cooperation, section 53(3)B of the MAA, and if the reduction assessment is ordered, that it follows section 54, 3.2 of the MAA. You want me to go over the evidence here?
Yes, please.
Okay, thank you. So, really, this is simple. We sent out requests for information to the business in question here, to the realty. And what was done was they supplied the wrong information for the wrong building. I have some income and expense mailers to hand out for 925 Corridon. And also in my brief, we have 929 Corridon, which is actually the tenancies from 925. So they mixed it up. So according to the Act 16.2, it states that these income and expense mailers need to be complete, true, and accurate, and this was not done. They were done inaccurately, and I have the evidence to hand out to support this. I have pictures here that show that they actually sent in the income and expense information from the buildings inside, and they were mixed up. If we want, we can take a look. We can just
Okay, we've got online documents, page about 6 pages into your brief, I guess. Is that what you're referring to?
yeah, so page 7 of my brief.
Okay,
This shows, this actually is 9225 Corridon Avenue, the Academy Florist. The pictures here that we can hand out, it clearly states on the window that this is 925. The property in question we're looking at is 929. So they mixed it up. So the information sent in wasn't accurate, and on that basis, I'm asking for non-compliance.
okay. And you presented something there that, Bellen, sorry, what did you ask me, Bellen? Can I see the evidence that was presented, or?
Yeah, so he has additional evidence
Yeah,
on the drive right now. I can scan it and add it, but we'll just need to reset.
is it just, Mr. Dolinsky, is it just to prove that the wrong evidence was submitted?
Yes.
Okay,
Also, I have a supplementary document to show that the parties are related. That's another issue. It's just to supplement our non-compliance issue. This issue that I brought up first it's pretty clear, cut and dry here. So I believe.
okay. I guess for my access, I guess Bellen will have to have them scanned, please.
Okay.
So we will again recess while the our assistant is doing the scanning, so we can have access.
Okay, thank you, Mr. Chairman. Just to, now that everyone has these documents in front of them, just referring back to the original brief I submitted, page 7, we have an income and expense tenant list, tenant verification form. We can see that the tenant listed here is Academy Florist Operation Incorporated. This should actually be for 925 Corridon. The property, our business in question here is actually part of 929 or Corridon, but it was listed on the 925 Corridon income and expense. So the extra evidence that was submitted today, item 2, file number 19-5900. If we refer to this third page, the tenant verification form,
You'll have to tell us which document.
Yeah, because
By
there's,
title,
is
Okay.
it, yeah,
because they're all O2.
oh, sorry. The title is 929 Corridon Ave Unit 3.
This one is a mailer.
It's the mailer,
Mailer.
okay.
So according to the mailer document, on the tenant verification form page, which I believe is the first page, we can see that this would be the correct information, but it's under the wrong address. So at our assessment department, when we're looking at data and we're doing our modeling, if the wrong information is sent in, we don't automatically look at the buildings next to it or down the street to see if it was mixed up. We just rely on what was submitted by the owners. So here we can see that the right information wasn't sent in for the specific roll number. And for that instant, and for this situation, we're asking for non-compliance. Then the picture document that was also sent in, I'll just grab the name. It's called A&T Photographs. It shows here that this florist store, if we look at the bottom right picture, it's zoomed in on the door. We can see it says 925 when it should be, when under the income and expense, it's under 929. And then the correct building, the premises we're looking at, is actually in 929, and the mailer sent in has it for 925, and that's the supplemental I&E we just brought up on our screen. So we can see it's mixed up here and we're backwards. So I believe this is enough evidence to ask for non-compliance.
Okay, thank you, Mr. Dolinsky. Mr. Either party have questions of Mr. Dolinsky's presentation?
Yes, Mr. Dolinsky, did you have an opportunity to review the realty file, including the board order, before presenting your evidence?
Just what's in my brief, briefly. I haven't looked at it too in depth.
Right. You are aware on page 2 of your brief that the request for non-compliance in the realty appeal hearing was denied?
I am aware.
Okay. And did you investigate as to why it may have been that the board denied the request for non-compliance?
I have not.
Okay. And respect to the mailers that have been provided, just looking at page 5 of your brief, top, the reference to the roll number, that is the realty assessment roll number, correct?
That's correct.
You haven't actually submitted a copy of the letter that would have accompanied these mailers that would have been sent to the owner, correct?
That's correct.
Is it fair to say you were present in the hearing room when we discussed 1717 Waverly, but is it fair to assume that the mailer would have been identical to the mailer that you would have sent to other property owners in that particular year?
I would say that's fair.
Right. So there would be, in fact, no reference to the business assessment roll on that letter, nor is there any reference to the business assessment roll on these forms that you submitted.
I believe that's correct.
Okay. And did you consider the Manitoba Hydro decision for making this request for deferral in this particular case? First of all, are you familiar with the Hydro decision that we discussed?
I know just minor details. I wouldn't say I know it in depth, and it wasn't considered in depth at all.
The additional handout that you had provided was, I guess, a 4-page document.
Yep.
On the first page there at the top, it looks like you see a whited out square, if you will. Looks like a sticker of some kind on top of the document. Did you investigate who would have covered up that information?
I did some investigation this morning, and it appears that's how it was sent in and scanned. I don't have any information whether it's on this issue.
Okay, and are you aware then, that, have you looked at Mr. Neufeld's rebuttal material in terms of the actual mailers that were provided?
I have not.
And I'll let Mr. Neufeld speak to the background of this, but have you investigated as to whether in fact there was an identical package sent to the city with respect to both 925 and 929 court? Was one package of information?
I'm not sure on that.
You're not sure on that? Okay. Those are my questions of the assessor.
Thank you, Mr. Mercury. Mr. Neufeld, any questions? Or we covered it. Okay, thank you. Ms. Rempel, any questions of the assessor?
Yes, I'm just wondering if you could clarify for me. So the information you received for 929 on Unit 3 was actually the information for 925? Or was it just the address that was 925, but the information was actually for 929?
Yeah, it got switched.
It got switched. Okay, that's all my questions. Thank you.
Thank you. Mr. McIntyre?
I have no questions.
Okay. My only question is, Mr. Dolinsky, so the subject is the dental center that you referred to in the picture?
Yeah, Smith, the Smith agency.
929 is the dental center?
1 second. Yeah, so the dental center is a different business, but yes, they're in the same building.
But is that the subject property?
The subject property is the Smith Agency Limited.
I guess what I'm asking is what is the subject property used for? Is it owned by Smith Agency and then rented or leased as a dental center?
Yes. They are a Winnipeg-based apartment, condo, and property management company.
Oh, so it is actually a Smith Agency office?
Yes.
For usage?
Yeah, so there's three, from what I found out from the correct information that was submitted for 925 Corden, which isn't on this document, but the accountant filled it out wrong, is that there's 3 tenants.
Oh, okay.
Yeah.
All right, we'll get into that later. Thanks. I was just trying to figure out which property it was in the pictures. Okay, that's my only question. Mr. Mercury, when you're ready regarding the request for non-compliance.
Right. So before I get into that submission, I thought it might be helpful just on a factual basis for Mr. Neufeld to speak to precisely what was submitted and how it was submitted, and then I'll speak to the reasons why the deferral request is
okay. Thank you.
First document is you have in your system is the assessor's brief from the realty appeal.
Okay.
On page 17 to 19.
All right.
Is what was provided by the assessor at that hearing. And the problem was that top of page 17, there was, I imagine, a label that was placed over a note. This is not the original submission. This has been altered. And without getting into the repercussions of presenting altered evidence, what ended up at the board, I presented the copies of the actual submission, and you have that in a 4-page package. And these are just the sheets. And you'll see that they do match up partially with what the assessor has shown you today. And it's each of these sheets for each property, a copy was submitted with both 925 and 929. And this is because they're managed and run as one economic unit. They don't have separate costs working out for them. Now, some of the costs may be separated, for example, property taxes, obviously. But if you look at the other costs on the page, insurance and property management, there's hydrometers that are all over the board. I think the water and sewer is a separate one. Waste and snow removal is combined, maintenance repairs combined, wages and benefits are combined. And you'll also note that it says gross. So these are gross, these are expenses on gross rents, and then the gross rent of 130,000 is listed. So the breakdown on each of these is then provided on the property address sheets, where it shows the unit and the length of the term and some comments on there. So each one of these had a package, and I can see that in the labeling of the package, it says 929, and this is Academy Forest, and they are in 925. But at the top of the page, it says with 925 corridor. So this is what was submitted. So I don't see how there could be any confusion on this. Each package was submitted separately. It's run as one operation. Now, the other differences that we noticed on this, the alteration, what the assessor just handed out, in addition to the labels being removed or hidden or covered, whatever, is on the page mark that shows the 929 rental table. And for those at the board here, you can see that this is what I'm referring to, where there are 3 lines for the tenants. The actual submission has some detail at the bottom. And you'll see this was the actual submission. And this was all removed, and we don't know how. And just so you understand that we are looking at the same document, there's a date stamp on these. And what we're doing with these is our office brought these down and we got them stamped. So this is the stamp that the assessment department put on these documents when they received them. And if the stamp is there, we have a copy of what was done, and all this was removed. So for someone to say that we may have mislabeled these is incorrect. We just presented the entire package as the unit is operated. And then we're confronted with some, I think, fairly serious issues of covering up the evidence that was actually submitted. So the decision of the board, of course, was to deny the penalty.
So I'll just pick up from there. So obviously, just from a compliance, the information was provided. Mr. Chairman, the submission that I'll make, I won't repeat it in detail, but it's virtually identical to it is identical to the property you just heard on 1717 Waverly. There's an acknowledgement by the assessment department that there was no reference to the business assessment role on the mailer, just as there was no reference to it in 1717 Waverly. And if this board is following the municipal board's decision in the Manitoba Hydro case as a matter of consistency, I fail to see how deferral penalty could have been applied here. There's absolutely no reference at all to the business assessment roll number. In addition to that, of course, we have the Board of Revision's own order on the realty, where they, even in the context of the realty, they denied the penalty. So we don't know anything more. Of course, the mailer hasn't even provided any evidence. So I'm not going to repeat the submission of the Hydro case, page 25, you have it. That is state of the law, leaving aside the fact, the concerns that Mr. Newfield has raised, where the information was indeed provided, but for those reasons, the referral request is should be denied in this case.
Okay, Mr. Mercury, I'm just looking at the file submitted, and you did submit that, I'll call it the final page with your summary of your argument on this particular property.
I'm sorry, you're referring to?
Your summary page of your argument that you would, I think you've included it with this file, I believe.
Correct. Yes, that's right.
Yeah, okay. Yeah, okay. I'm just making sure it's there because you referred to it last time in your summary. Okay, I've got it now. Okay, thank you. Okay, Mr. Dolinsky, any questions on or comments from what the appellants have presented?
Yes, thank you, Mr. Chair. Applicants, do you acknowledge that this is a multi-role submission?
Which submission are you speaking of?
So you're saying that as per the income and expense mailer, 925 was sent in with 929 forwarded. So that means we're looking at expenses that are combined under a multi-role format?
Yeah, I think that's fair to say. We were able to break down gross income from each unit, but unable to break down the expenses and therefore unable to present the net income.
Okay, thank you. One last question. Do you acknowledge that the Smith Agency Limited is a related party to the owner of the building?
There's some interconnection, but the Smith family have owned and operated buildings in Winnipeg for 108 years. And they have a portfolio of properties that are owned and operated by different individuals over that time period. Over 100 years, you do make a lot of other business partners. So there's United and Gopher are their main property owning ones, but they all have different officers and different shareholders and different people. So then Smith Agency, who don't operate buildings, was set up as a management company. And it's just Dave Ross and Tom Smith who run that, not the other, any of the other investors. So I think it's fairly common in the real estate world there are often, you know, opportunities and investments that come along, and the people who own them are often similar.
Okay, thank you. So with that new information brought to the board, would you agree that the owner occupied box should have been checked on the INEs that were submitted?
To realty? No. I mean, the majority of the building is occupied by two retail tenants, a dentist and an olive oil sales place. And the unit in the basement being the subject of this debate, which is Smith Agency, has some interconnection. So I would say on the basis of square foot, well, no, I don't think that they could really say that. I think it comes down to more of a legal debate that I wouldn't know how to answer that question. I wouldn't have put owner occupied. I don't know what they did put.
It's a legal question in the sense that herein lies the difficulty. You have one mailer sent with respect to only the realty assessment roll number identified. So you have to keep in mind that when the recipient of this document receives it, it's only in relation to the realty assessment roll, not the business assessment roll. And so, of course, you don't have separate realty assessment rolls for various different tenants here. There's one roll number, and there are multiple tenants there. It's not owner occupied.
No, I think the shareholder ownership on The building is Billingsley Holdings, Gopher Enterprises, and Waverly Holdings, whereas the ownership of Smith Agency is Dave Ross and Tom Smith. So even going through the shareholders, I'd probably say no, it's not owner occupied.
Okay, I just wanted to ask you about these company searches that were put in my brief, and the one that was also brought in for extra evidence. The document names A&T Company's office. So on page 3 of my original brief that was that everyone has, we can see that we have owner of the building here at the top, United Investments Limited. Would you agree that that's the current owner, the realty owner of the building?
Yes, I believe so, yes.
Okay. And then underneath we have the owner's David Ross highlighted.
I'm sorry, where do you see this?
Further down on the left column, it's highlighted.
The director?
Yeah, director information.
No, he's a director. He's not listed as an owner.
Okay. You agree that he's the director of the building?
Sure.
Okay.
I found out the other day that Gary Dewar is the director of Air Canada. I don't think he owns it though.
I agree. Okay, so and then the document that I asked for everyone to bring up, please, A&T Company's office. We can see that Ross David is also the director here for the Smith Agency. So there is a very good chance that we have related parties. I just wanted to bring that up. You're saying that.
Well, there are some common directors in both companies, and of course that's clear. And in the world of corporate structure, that's not uncommon. You can be directors of a corporation. Most major corporations tend to like to have a nice board of directors from different places in business. And a former prime minister, for example, can command about 12 directorships. That's just the way company structures are. But I was looking at the shareholders.
Thank you. I have no further questions.
Thank you, Mr. Belinsky. Mr. McIntyre, any questions?
I have no questions.
Ms. Rempel?
Yes, I just have a couple of questions. I'm wondering, did you submit the packages for 925 and number 3929 Gordon yourself? Did you send them in, or did you have them delivered?
I don't recall exactly. What we've been doing is trying to hand deliver, and this was done in 18. So they were hand delivered. I don't know if it was Randa at Smith or one of my people who brought the package in. But it was one of those two people who brought the package in.
Did you prepare the packages?
We helped prepare the packages, yes.
So you indicated that there was information that you are alleging was removed on the form that you actually personally prepared?
No, I did not personally write this. This is Randa Martel's writing, and I asked her. I said, "What's under here?" And then she sent me the photocopy, because what we've been doing is, and we started doing this around 2016, is we take two packages and we bring them to the assessment department and say, here's our mailers, stamp these for our receipt, and we want them back. So the one I'm showing you with the full information was stamped and returned. And that's her photocopy.
And can you tell me what information it was that was removed?
Well,
and how it's relevant to this hearing?
Yes, the most important removal, of course, was at the top, where on the assessor's package, he has a whiteout showing here at the top. I don't know if everyone can see this. And it says on this one, it says with 929 Gordon. And on our package, we show that. Now, regardless of what position the assessor would like to have, like they don't like multi-role, unfortunately for them, there are a lot of buildings that they can't separate because they're multi-role, because of the way they're operated. And in this particular case, they've been running these for 100 years, which is longer than there's been an assessment department. But the point is that the reality of the situation is we can only give the assessor what the information that we have. We're not creating new information for them. It's all that they have. There's nothing more than this.
So I'm wondering why information for 925 and number 3929 were submitted together when information for the other tenants in those buildings was not submitted.
Oh, no, it was like, well, this was the package. This is my exhibit. This was the package that was submitted for both 925 and 929. So the whole thing was submitted together. And it showed, Academy Florist, which is 925. And then in 929, we have the dentist, the olive oil, and then Smith Agency. So they were all submitted together on the one sheet. So that there was they had a full package. And unfortunately, there was some labeling concerns, but if one didn't have this little thing whited out, you would see it's very clear to anybody what happened, that the information was all there.
That's all my questions. Thank you.
Thank you. And I have no questions either. We will recess for the panel to consider arguments presented by both parties, please. And could you leave the room? Thank you. Thank you. Okay, I will now call the hearing back to order. The panel has considered arguments by both parties, and it is our opinion that the request for non-compliance be denied in this case. So, Mr. Galinsky, when you're ready, 929 Gordon Avenue, unit number 3, the BA assessment appeal, please.
Thank you, Mr. Chair. We're asking to confirm the total annual rental value of $35,940. This is based on a base ARV of $29,271. ARVs per square foot comes to $10.73. The area is 2,728 square feet. The total occupancy cost totaled 6,684 square feet. This brings us to the total annual rental value of $35,940. Turning to page 17 of my brief, please. We have on page 17 and page 18, we have 65 comparables to justify this base ARV of $10.73. I'm not going to go through all the comparables, but we can see here we have a wide range throughout the city of OFS comparables. The total area of all these properties is 141,551 square feet. The average for these properties on a per square foot basis is $14.06. The weighted average $13.86, and the median $13.75. So with this information, I believe the assessed value of the annual rental value of $35,940 should be confirmed. That's my presentation. Thank you.
Thank you, Mr. Galinsky. Any questions by the appellants?
Yes. The comparables you mentioned, page 17 and 18.
That's correct.
And there are 65?
Yes.
And how many of them are basement spaces?
I don't believe there are any basement spaces on.
Okay, would a basement rent for the same that you're suggesting as upper level space?
No, they would not.
Did you have a chance to review the Board of Revision decision?
Yes.
And there was a change, correct?
Yes, correct.
And board actually stated this was based on the net operating income presented by the applicant.
That's correct.
Did the assessor appeal this decision?
I don't believe so.
Thank you. Those are my questions.
Thank you. Mr. McIntyre, any questions of the assessor?
I have no questions.
Thank you. Ms. Rempel?
I have no questions, thank you.
And I have no questions either. Mr. Neufeld, when you're ready, please.
Again, very simply following the direction provided on the realty order. Page 3, pretty clear. Net operating income presented by the applicant, that was us. We said 814, that's what the decision was. And there's been no new information presented here that should change anybody's opinion as to what the value should be. This is basement space. There was another document, and I did not introduce it into evidence, but I am going to refer to it because it's a standard. And that is the standard of measurement by BOMA, retail measurement in this case. And one of the things, there was a question earlier on how the auto dealer was to be measured. Was it demise? And that is an important distinction. When you have demise space, you can rent it separately and it counts towards this. Now, this is basement space. In most cases, basements are not rentable. This one, they did the work to make it rentable. But remember, it's still not barrier free and it has a limited use. And because the use is not serving the retail public, they don't have to put in the barrier free. This is a property management and it's inferior space. So without beating this to death, we're just looking for the same decision as the realty, and nobody's showing you anything differently today. Should overturn previous realty ruling. Thank you.
Thank you, Mr. Neufeld. Mr. Dulinski, any questions of the appellant, please?
Yes, thank you, Mr. Chair. Well, sorry, Mr. Neufeld, can you tell me what the square footage issue was?
One second. You have listed, or are we in disagreement? We both are at 2728.
278.
Yeah.
Okay, so there was no issue on this?
No, I don't think so. I mean, I know earlier on, about 6 or 8 years ago, there was a question on the measurement because the entire basement is not rented space, would be called a common area.
Okay, thank you. I have no further questions.
Thank you. Ms. Rempel, any questions of the appellant?
No questions, thank you.
Thank you. Mr. McIntyre.
And I have no questions.
Thank you. And Mr. Neufeld, I'm looking on page 3 of your, I guess it was the brief you presented at the Board of Revision Realty Appeal.
Yes.
So we're dealing with this subject property is the basement area only.
Yes, that's correct. Only the basement.
Yeah, so I'm looking at your workup presented on page 3. So there's basement and there's upper, I guess that would be main floor, I assume, a total of 5,456.
It's the dentist and the olive oil sales place. And then the basement is occupied by the property manager.
So there's a business running out of the basement?
That's correct. That's the subject of this appeal, yes.
And that's Smith Agency, is that right?
That's correct.
Okay. And you come up with the $8.14 a square foot. How did you come up? You're using the same for the for your presentation today at the BA appeal. Where does that 814 come from?
Well, I guess you've heard the debate already on the penalty issue, and we have combined operating costs, and we have different incomes. So we went through the whole site and tried to calculate the net incomes for each of these units, and so that's why the number's odd, because they're semi-gross, and we worked it out that way.
Okay. That is my only question. And your final value you're looking to revise to is 28,890. Is that correct?
That's correct.
Okay. And is that divisible by 12? Just out of curiosity.
I don't know.
It is not.
Oh no. Okay, yes, it's 28,884, or if you go one way, or 28,896 if you go the other way.
We need a rounded number.
Well, then I would go to 28,860. That's divisible by 12. No, the 896 would. So is the 896. Do you want a zero at the end or not?
Yeah.
Okay. And you got to go down. You can't go up. And it's got to be 28,860.
28,860. Okay. Thank you very much. Okay. Sorry. Here, I'll just get back to the screen. There we are. Okay. So any requirement for summary on either party?
Very, very brief.
Okay.
I know it's not pleasant to look at, but I just realized that I was asked to remind the board that this is basement space. I took these pictures in the property, it was about a year ago, and they were submitted as an additional exhibit. And there's a 1 page with 4 pictures. That's a sewer backup, and not land drainage system. That's a sanitary backup. It was pretty bad. They actually stripped down the entire basement and had to rebuild it. I thought it would just end on a pleasant note. No, it was bad.
Okay. Would there be an age variant warranted? Okay. So that concludes 929 Corridor Avenue, unit number 3. And that concludes our hearing today. Thank you to both parties. Have a good day. Thank you.